Next case is In re Hill, Department of Health and Human Services versus Hill. My understanding is that time will be split in each of these two cases. The Department of Health and Human Services will split its 15 minutes between two advocates, and then the respondents will split their time in some unknown way, but it's at your discretion. Please measure your own time. And it's also my understanding that we'll have an additional 5 minutes afterwards of argument from the Children's Law section of the State Bar of Michigan. Okay, please proceed.
May it please the Court, Dominic Andriacki Jr., and I represent the appellants. At council table is Professor Sankaran, who represents the Legal Services Association, and Sarah Wadlick, who also represents the Legal Services Association of Michigan. Professor Sankaran will be discussing the broader systemic issues that In re Hatcher has created. As for me, I had originally memorized what I wanted to talk about, but this morning I said, I just want to talk to you guys about this case. The main thing that really bugs me about this case, Your Honors, is that it takes about 10 to 20 seconds to read the advice of rights out before someone gives their plea. It's right in the Michigan court rules, and I believe it's also in the Child Protective Proceedings bench book. The Hatcher rule, the way that the Hatcher rule is being applied is that it's cutting respondents off at the knees from being able to raise problems in the adjudication that amount to constitutional problems or due process concerns. So when I was thinking about Hatcher and I was thinking about applying Hatcher to adjudications, I thought, what if Hatcher didn't apply to an adjudication order? Would that automatically mean that every single respondent, when they appealed, anything having to do with an adjudication, would that mean that they win every time? And I was thinking about that, and I believe the answer is no. The reason why is that even in a plea case, but the vast majority of these cases are plea cases, if you have the plea and you appeal something with the plea, it's going to be something that's a major error, like a due process error, like we have in this case. So you're going to have things that are plainly erroneous, like not telling a person about their rights, or not appointing counsel, not having a jury trial, things of that sort. If it's a jury case and you appeal it later on after termination, you're going to appeal the same kind of issues, but you can also appeal an evidentiary ruling. But that's at an abusive discretion standard. So that's going to be a very high burden for an appellant to win on. Also, the other thing you could do is you could raise issues with maybe the jury instructions, but that, again, is a plain error standard. Again, it's going to be a very high burden for an appellant to win on, for a respondent to win on. So the long and short of it is, if this court says that Hatcher doesn't apply to adjudications, it's going to allow courts of appeals or the Supreme Court, depending, to cure problems that are just egregious, like happened here. And if the court had any questions about my thoughts on that, again, Professor Sankaran will be discussing the broader systemic challenges, and I would refer to him to that. But if the court's had any questions for me.
Doesn't appear so, counsel.
Thank you
very much.
Good morning, Your Honor. Vivek Sankaran on behalf of the Legal Services Association of Michigan. I appreciate the opportunity to address this court on these issues. There are two overarching issues that I think the court needs to confront today. One is the sort of policy question of whether Hatcher, as a rule, makes sense in a child welfare case, given that unlike the cases Hatcher relied upon, these are one continuous proceedings from start to finish and not two separate cases. So this is sort of an interlocutory order in the middle of a longer case.
You cite a number of cases where when there's collateral bar rule applies only when there's two separate proceedings. And I really question, is that a distinction that is material here when these proceedings, while technically one, are broken into two separate proceedings, each with a right of appeal, the adjudication phase and the dispositional phase?
So Your Honor, I do think that there are separate parts of one continuous proceeding. I think you've led right into my second question, which is even if the court believes that Hatcher, as a matter of policy, makes sense, that let's require a sort of a half-time appeal to deal with the first half of the case, the second question is whether our court rule sufficiently gives notice of those involved in the proceedings of when they need to appeal and what they need to appeal. And that's really the issue. You know, in our brief, we talk about why we don't think Hatcher is good law. It's that second issue that is my deepest concern with the way the court rules are structured in Michigan. So right now, the word adjudication appears nowhere in MCR 3.993 in the appellate process whatsoever. The Court of Appeals has repeatedly held that an adjudication is a non-final order. So if you look at short orders at the Court of Appeals, if someone tries to appeal directly an adjudication order, they will dismiss the appeal. There's no appeal as of right to that adjudication order. So then you go to the next appeal, which is the order of disposition, right? The sort of the end of the first stage, as you put it, Justice Zara, of the child welfare case. And one of the flaws in Hatcher was it presumed that every single order of disposition is appealable as of right, and that is clear to litigants affected in a child welfare case. But if you look at the plain language of MCR 3.993, it actually doesn't say that. So MCR 3.993 talks about two types of orders of disposition that are appealable as of right. First, it says an order of disposition placing a child under the supervision of the court. Those are the exact words in the statute. The Court of Appeals, in a published case called Inri McCarrick, has said that that only applies in juvenile delinquency cases. That's a term of art, supervision of the court, that applies in a juvenile delinquency case. Let's take that sort of out of the category of child welfare cases. The second class of orders of disposition that are appealable as of right are orders of disposition removing a child from their home. What that creates, though, is sufficient ambiguity, because in a case like this, the order of disposition is not the order that removed the child from the home. In this case, the child had been removed for months prior to the order of disposition. And so after I got the Attorney General's brief, which was very thorough and helpful, I went and looked at short orders of the Court of Appeals to see how they were dealing with this issue. Because one of the challenges is that it's not in published decisions. These are sort of orders dismissing appeals. And in many cases, the Court of Appeals is interpreting that language as this court would, under the plain language of the court rule, which is that if a kid had been removed previously to the order of disposition, there are panels of Court of Appeals judges that say, well, this isn't an order of disposition, that he's removing a child from the home, because the child has been removed from the home already. And so I think it's that second issue, that even if this court determines that there are valid policy justifications for a Hatcher rule, the reason this issue keeps coming up over and over again at the Court of Appeals and the Supreme Court is that our framework that we've created in child welfare isn't clear.
So, Mr. Sankard, should we, if you were the sole justice on this court, would you hold this case in abeyance and do an ADM process to figure out how to make sure our court rules serve all of the interests in these cases well or better than they currently are? And is that what we should be doing to figure out how to solve the problems that Hatcher seems to have created?
So that's certainly a possibility. What it doesn't resolve, though, is what we do with all the cases in the pipeline that where litigants. So I honestly believe in this case, in a case like Inri Hill, the first order appealable as of right, I believe, was the order terminating parental rights, because of the ambiguity in the court rule, where that child had been removed prior to the order. So in this
particular case, it may not be a Hatcher problem because there was not an appealable order until the termination order?
That's my reading of the court rule. And I think that's the plain reading of the court rule, is that the order of it's one of these assumptions that we've made in appellate decisions throughout sort of Hatcher, and having Hatcher created that, which is that every single order of disposition is appealable, but that's just not true. And so I think for the cases in the pipeline, if it wasn't an appeal as of right at the order of disposition, I don't think this court has a choice but to send those back down.
Isn't it the first disposition order? I don't know that every disposition order is appealable by right, but it's the first disposition order that's presumably appealable by right, is it not?
It is the first disposition order, but then the language in the court rule actually says the first disposition order removing a child from the home. It doesn't actually blanketly say just order of disposition. And I think, looking at the...
Doesn't that clearly mean pertaining to that subject? Pertaining to the removal of a child?
It just says the order of disposition removing a child from a home. And I think one of the great things in the Attorney General's brief is the cites to the other states.
Yeah, tell me about that. I tried to read all of them, and it seems like it's not always an apples to apples comparison. Is there anything to learn from those other states' rules?
So I think that the takeaway for me from those other states is the clarity they provide in this process as to when you need to appeal and who needs to appeal. So, for example, a number of those states, Vermont, New Hampshire, clearly state that every order of disposition is appealable as of right. We don't say that in Michigan. Right? Our court rules don't broadly construe it that way. A state like Arkansas says that every order of adjudication and disposition is appealable as of right when out of placement has been ordered. Again, broader. It doesn't talk about the order being the one that is removing a child from the home. It's sort of a passive tense, so it talks about actions that may have happened previously.
So it would sweep in a case like this one?
Correct.
Yeah.
And so I think that's the biggest value, because I think you're right, Your Honor, that every state does child protective cases a little bit differently. Some construe them in a very collateral way. So even on things like right to counsel, they don't appoint right to counsel in the adjudication dispositional phase, but when a brand new termination case is filed, it's a separate case number, a separate statutory scheme. Those cases I don't think are that helpful because we do things a little bit differently, because we've always construed these cases as one continuous proceeding under the same code. But I think if you look at the details of those statutes, that's where the lack of clarity that we have in Michigan really comes it becomes apparent. In two of the cases that are cited in the AG's brief from Florida and Vermont, the court specifically cited the ambiguity in their statute as a reason why they were reversing the judgment, because there was not clarity to litigants as to when to appeal. And so language in Florida stated that the statutory scheme is ambiguous in terms of alerting those affecting as to when they need to appeal.
So this is all a means by which you're answering in the affirmative to Justice McCormick that if the rules were made less ambiguous and more clear, that would be at least a significant step in the right direction.
Huge. Yes, I would completely agree with that statement.
Well, concerning the cases that you mentioned that are in the pipeline, and I understand there are a number of cases, including, of course, this one, and I recognize that there was clear error in this case, but I'm having a little bit of difficulty understanding how in this particular case those errors are mounted to doing any harm to the respondent as opposed to being simply harmless error. She hasn't even alleged, to the best of my knowledge, that she would have pled to the allegations in the petition if the trial court had properly advised her of the rights that she was waiving. And even if she had made such an allegation, I don't know how the outcome of these proceedings would have been any different, because it's hard for me to believe that there wouldn't have been some determination at the adjudication that there were one or more statutory grounds alleged in the petition. She abused drugs, she was incarcerated, she'd been incarcerated on several previous occasions, and she had no appropriate housing for the children. So while I certainly can understand that in some cases there might be some harmfulness to what the respondent had been deprived of during the adjudication phase, is this such a case?
I don't believe I can answer that question, in part because at the adjudication stage, the standard is just a different standard than what the court had to find at the termination stage. So for this court to say that the error was harmless, it would have to, at first instance, apply the evidence in the record to a brand new statutory standard, which is the jurisdictional standard. So that's sort of one key difference between the termination stage and the adjudication stage. The second is that the evidentiary rules and the procedures are very different at the adjudicative stage and the termination stage. So, for example, at an adjudication trial, you have the right to a jury trial. You lose that at the termination stage. At the adjudication stage, you have the right to the rules of evidence being strictly applied. You lose that after a valid adjudication. So while you might be right, Justice Markman, that in the end, the trial court may make the same decision that the standard was met. Because of the vastly different procedural safeguards at adjudication versus termination, it would be speculative for this court to engage in that sort of analysis.
So, I don't mean to be difficult in asking this question, but if you're right, would there ever be harmless error?
At the adjudicative stage, with a flawed plea, no. And this court's never actually engaged in harmless error analysis with an invalid adjudication. I mean, in the Wangler case, the court never assessed whether it was a harmless error. It was more of a structural error in that a invalid adjudication was automatically viewed by this court as reason to reverse the subsequent termination decision.
Do you think harmless error analysis makes sense if we feel like, at least for the cases in the pipeline, we have to...
Again, I don't see how this court would do it. I mean, this court would have to sit almost like a trial court applying a completely different legal standard. Right? So it would be one thing if it was a termination case and you're trying to figure out whether a piece of evidence that was introduced into evidence was, it affected the outcome. You have the trial court applying the evidence to the standard, and you can sort of piece that. This is a completely different finding that the court would have to make under different procedures. And so even the lack of a jury trial, I mean, that in and of itself, I mean, in this case, if this court does reverse and remand because of the invalid plea, one of the procedural rights that the mother in this case would have is the right to a jury trial. And so I think that's what makes this error such a different type of error than simply sort of a procedural mistake in the same case.
I know your time is up. I have one more question, though, just sort of to get my head around what the different ways of thinking about this would mean on the ground. I mean, it seems to me that the one continuous proceeding that Justice Corrigan described makes sense to me because, as I understand it, a lot of parents will plead guilty at the adjudication stage so that they can get on with the disposition stage and get their kids back. I assume, do what they need to do, and I assume and I know the goal of the process is to get families reunited, and so I assume some number end with that happy result.
Yes.
And some number, on the other hand, maybe like this case, you can tell me better than I can, that the kids have been removed even before the adjudication, and then for a long time they've been living in some other home. They have some stability, they have formed new relationships, and so by the time there's a termination, it can be especially disruptive for a court to go back and start over for the kids. And I don't know, how do I think about that? How many of the cases are going to fall into that category?
So at the dispositional phase, the vast majority of cases in Michigan, the goal is reunification at that stage of a case.
Say what? I'm sorry?
The vast majority of cases, the goal is reunification at that order of disposition.
Yeah.
And so one of my concerns that we write about in our brief about the Hatcher rule is that we incentivize adversarialness at a time in a case where I think as a system, we don't want large numbers of disposition appeals. But at the same time, without providing them some opportunity to clear an error or address a mistake that was made, the question is when can people bring that up? About half of children in Michigan who are in foster care, roughly half go home. But I think you're right that in fashioning a rule, one of the struggles is that every case is somewhat different. And so how do we create a rule that broadly applies to all spectrums? In the end, we believe that the Hatcher rule perversely incentivizes too much litigation that would then slow down a child protective case if more people took advantage of this appeal, which is why we believe that the appeal should happen at the end of a case.
Mr. Sankaran, I'd like to follow up on my colleague's question, if I might. And, I respect your knowledge and expertise in this. You really have a great deal of expertise in this area, but it seems to me the fundamental problem is you have two extremely important interests, the parent's interest and the children's interest, and both of them have to be taken into account, and that's what the legislature, perhaps imperfectly, has tried to do in this process. I mean, what would happen as a practical matter in this case and presumably in a large number of other cases if we were to grant relief? It would clearly require the whole process to begin again. There'd have to be another adjudication hearing. There'd have to be another service plan, more dispositional hearings, more opportunities to comply with the service plan. And at the end, you might still end up with a termination. But prior to that termination, you would have extended what is in this case approximately a 3-year delay into a 6-year delay. How can that possibly be compatible with the interest of one of the two major stakeholders in this situation, the children? This is exactly what would happen. It would be a replay of this entire process in which the legislature, however imperfectly, has tried to create some kind of balance so that the fundamental rights of the parents could be taken into consideration and the fundamental needs of the children could be taken into consideration. Hatcher does that. And a further clarification along the lines that you seemingly approved of a few minutes ago, that would provide greater guidance to the parent as well. There'd be more warnings, more timely notifications of what their rights were at various junctures of the process. But it would do so without creating the situation where every time there's some kind of error, almost any of which can be characterized as a due process error at the adjudication stage, you can wait until after the end of the disposition stage, after the adoption, after the transfer in foster care, and you can force the whole process to be done again. That just can't be right, can it?
Sure, I certainly don't disagree that there are a number of different interests in a child protective case. Much of the work that I do on the trial court level is on behalf of children. I do disagree, though, Your Honor, with what would happen necessarily on remand. I think that the court would have to do a new adjudication hearing. I don't know anything in the law, though, that would require the court to have to redo the dispositional phase of a case. A number of cases in Michigan go straight from adjudication to termination right away, even at the outset of a case. And so in a number of these cases, depending on what the evidence is, I don't believe there's any legal requirement that you'd have to go through the review hearing stage. What would happen, though, and I think this is an important issue, is that a reversal in this case would send a nice, strong message to trial courts that the adjudication matters. And I think that's a good adjudication serves the interests of both children and parents, because at the adjudication stage, their interests aren't different. Until we prove a parent unfit, the U.S. Supreme Court and other courts have held that the interests of children and parents are aligned. And what we're seeing in this court and at the Court of Appeals is a significant number of adjudications where if we don't even advise people of their rights before entering a plea, but I don't think that for remand, and I know my time is grossly, I'm over, but I don't think for remand the lengthy proceeding that you envision, Justice Markman, would have to occur. If there are no more questions, I appreciate the Court's time and the opportunity to address this.
Thank you for your time, Mr. Sankaran.
Thank you, Chief Justice, and honored members of this honorable court. Kurt Harmon, appearing on behalf of the Department of Health and Human
Could you
Services.
speak into the microphone just a little bit more closely, please?
I'm sorry,
Thank you.
Your Honor. Also at council table, we have Ann Sherman, who will be sharing time with me, Eric Verstucha from the AG's office, and Bill Ladd, who this court has given 5 minutes in regards to argument. I believe that generally speaking, there was an error that took place. But as looking at the Court Rule 3971 in a whole, it says, or in writing that's made part of the file. As we go through this particular court case as it took place, the referee at the initial hearing read the entire petition into the record and to both of the parents at that time. And after that, the summons that brought her to court that day and the summons that brought her to court at the continuation after counsel had been appointed, the summons in order to appear that brought her to the formal hearing, being CJ 21, states specifically you've got a right to an attorney and explains that, states specifically that she's got a right to a jury trial, right to trial by judge, and does say, warning in bold letters, you're notified that this hearing may result in a temporary or permanent loss of rights to your children. So while the court did not specifically on the record in open court explain to her rights and ask her and indicate and ask whether she was waiving those rights in regards to a jury trial, as a whole she was informed of her rights by the summons order to appear and also by reading of the record, reading of the petition within the record kind of a thing. believe that what was not done, either in writing as made part of the record or orally in court, was asking her, if the court accepts the plea, whether she gives up her right to a trial by judge, by jury, and those associated in 3A through E. And I believe that for the consequences of the plea not necessarily are violated because of the fact of the warning that was articulated within the summons. So while he did not explicitly go through the requirements and the rights of 3971, I believe that the paper and the writings that do exist in this matter adequately informed her of her rights, and that she then chose the way. Going through, our referee is a little bit of the older school. He uses the outdated court form PC09A and the record of preliminary hearing. And the transcript shows that at the continuation, after the removal, after the continuation of that preliminary hearing, after counsel had been appointed through counsel, she had not contested. She was not contesting those matters in regards to the factual basis of the petition. She appeared in person at the initial hearing. She was brought over from jail and attended that one. From there, she attended all the proceedings by Polycom, being incarcerated in the state's prison. So we believe that no error is necessarily harmless as it relates to due process, but under these circumstances, what's going to happen if this court elects to reverse this matter? We'll be back. We'll be filing an original petition again. That petition may or may not contain a request for termination, and we're going to be working our way through the system in regards to all those factual matters that were in the original petition, the factual basis that supported the request for termination, and her actions since the termination. If there's no questions, I'd like to share the rest of my time with...
Well, I have one question.
Yes, sir.
Can you share your thoughts concerning Mr. Sankrin's response to my characterization of the redo that would be necessary upon a finding of some error? I know you argued there's no such error in this case, but assuming there was an error in the adjudication stage, I suggested that a fairly expansive redo would always be potentially available, and I think Mr. Sankrin suggested it wouldn't necessarily be so. What is your thought on that?
My thought, Your Honor, is that redo will be extensive in regards to time. She's already chosen in regards to exercising appeal to this level. We would have a petition. She would exercise her right to a jury trial, which is fine. It's her right and entitlement to. I suspect that there would be an appeal from that jury trial determination, and it would have to work its way through the courts. I see at least another year to 18 months of limbo for these children, Your Honor.
Okay, thank you.
Thank you, Your Honor.
Good morning. May it please the Court, Assistant Solicitor General Ann Sherman here on behalf of Amicus Attorney General Bill Schuette, supporting the Department of Health and Human Services. It's crucial here that the Court consider the practical aspect of what the Hatcher Rule means and the possibility that we would not have the Hatcher Rule and its protections. As a practical matter, it would be an absolute futility to allow a parent to raise procedural errors that have occurred in the adjudicative phase after parental rights have been terminated, when the same evidence that supported the termination of rights at a higher standard, clear and convincing, is going to support the state taking custody of the child the second time around at the lower standard, preponderance standard. So the parent ultimately doesn't benefit from that delay. And of course, the parent can still appeal the final determination decision for sufficiency of the evidence. But the child certainly doesn't benefit from that delay. The child who so desperately needs permanence and stability is going to, as you just heard, wait an additional 18 months, 2 years, possibly even longer, while this process runs its course. And what's going to happen to that child in the meantime is that some adoption that's been in place is going to be derailed, or that child is going to start to experience behavioral difficulties. Why? Because children need to know where their bodies are going to be.
Ms. Sherman, I mean, correct me if I'm wrong, but I thought if a parent was appealing a termination ruling, and it would be improper for an adoption to be finalized. How could that happen?
It can't be finalized. Nevertheless, there are at least proceedings that can be in place. Adoption can't be finalized without the termination.
We permit trial courts to start the adoption process when a parent is still appealing a termination ruling?
I'm not sure about the answer to that, honestly, Your Honor, but
I told you, I'm pretty sure the answer is no.
No, but
I might be wrong?
But my point is that between the time of the termination, where the court then would be saying, what are we going to do? Where are these children going to be? And obviously there are foster parents that might be wanting to adopt. The children might be there in the foster setting at that time. Now we're going to take that child who's possibly in a foster setting, and we're going to start the process again. And on top of what might be the time for an appeal, we're talking about a new petition, we're talking about an additional delay. That's the time where I think that the adoption discussions would be happening. And that is going to be delayed. These children are going to be frustrated. They want to know where they're going to be, where their forever home is going to be. And that's an unnecessary delay for that child. Because what we need and what Hatcher stands for is that the appeal would happen immediately after an alleged procedural error in the adjudicative phase. And that's really when we need it to happen. There's no point, practically speaking, in making that appeal process after the termination hearing. Because, again, the evidence that went to the termination of the children in the first place is going to support the parent taking custody. And the one that really loses in that circumstance is the child. You know, even the amici on the other side.
It sort of depends, right? I mean, it depends how you frame it. If the child's parent has been wronged in a substantial way, then it probably hurts the child that the parent was wronged in a substantial way, right? So, I mean, that's all arguable. But obviously, there will be cases where I raised this question with Mr. Sankaran, where we want to worry about taking too long to give the child the kind of stability the child needs. Why was Justice Corrigan wrong when she described these proceedings as one continuous proceeding?
Because yes, it's one case, and yes, there are ongoing proceedings, but the custody trial and the termination decision, they are two discrete questions. The court rules make them so, and the legislature has made them so. This court has said that the custody trial is of singular importance. It's a crucial decision in the process. And even the amici on the other side has said that is the time when the autonomy of the family unit is pierced, and that is what allows the court then to decide what's going to happen to that child in the future. So that question at that time in the adjudicative phase is, right now, is there abuse and neglect? And then you've got that whole period of reunification efforts, at which time then the court is going to look and say, were the efforts successful?
Well,
The
court has control of that process, but the outcome is in the parent's hands. If the parent complies with the plan, then reunification occurs. And there are instances where, the parent has done all that's supposed to be done, and the trial court can't terminate at that point in time. So why wouldn't that then suggest it should be one proceeding? Because really the outcome is in the parent's hands.
The outcome is in the parent's hands, but in that first proceeding, that is a game changer when the parent actually loses the custody of their own children and the state essentially takes over as parens patriae. That's a dramatic shift in the parental-child relationship.
Isn't it true that in practice, in most cases, the parent pleads to the adjudication because they want to get to the point where they can get their children back? I mean, am I misunderstanding how most of these cases go? I thought
there are many pleas. I can't say that it's always because they just want to get on with the process.
Well, I thought it's because they wanted to get their kids back, and the best way to do that would be to satisfy the court that they can fix the problems that got them there in the first place. Is that fair? Is that fair?
I think it's a fair assumption for some parents that is their thinking. It may not be every parent.
Do you agree with me that it's the department's goal to reunify wherever possible? That
Absolutely.
To the extent we can keep families together,
Absolutely.
We know that the department wants that?
Absolutely.
What's the percentage that are in foster care at that time? Sorry.
Oh, go. Thanks. Take over.
What's the percentage that are in foster care at that adjudication phase?
I think obviously I don't know the percentage. I think it depends on what the initial has been in the initial petition. If there's something in the initial petition that says the children need to be taken from the parent immediately, then there will be a preliminary hearing. If there isn't, the court does a preliminary inquiry to find out whether the children should be in placement.
I guess the point I'm driving at is if the child is still with the parent, even if the court's in control, that family unit has not been separated.
That's true, but the parent is still, if that's true, then the parent is with a child. But in what you're talking about with the custody hearing is the state taking custody of the child from the parent, and that is a distinct, dramatic event. Very distinct from the period of time where, as you say, Your Honor, you have the time for the parent to prove that there is no abuse and neglect, time for the parent to show that all of the circumstances that led to the petition in the first place have been rectified, and the parent always has the ability not to have their rights terminated at the end. Now, in that isolated circumstance where the adjudication phase and the termination has such a dramatic effect on the termination hearing that it really does seem fundamentally unfair, that can be dealt with in the termination hearing. For example, if we have a circumstance where the parent has pled at the beginning, and you asked, Your Honor, about the pleas, if the plea has been not knowing and not voluntary, that can be dealt with in the termination hearing. The judge can decide not to give preclusive effect to that plea, and the Attorney General would support that.
Well, if that's the case, then there'll be the parent won't have much luck on appeal. If it's been taken, if the trial court took care of it at some point, we won't be here. So that's not really a concern, right?
Yes, but some of the cases, like In re Hudson and In re Mitchell, have talked about errors in the adjudicative phase compounding the termination hearing. But the point is those can be dealt with in the termination hearing. That's not a collateral attack under Hatcher, because the court is not setting aside what happened in the adjudicative phase. It's simply remedying it in a different way. And I want to point out that with respect to whether there's actually an appeal of right, Hatcher is predicated on the ability to take an appeal from the custody decision in the adjudicative phase. Now, this court can clarify that if it believes it needs clarification, but we need to have these litigants.
Have you guys talked to Judge Talbot yet about all the new appeals that we're going to have if all the parents have, and how does he feel? Should I get him?
I have not talked to him, Your Honor. I could imagine how he feels. If there are no further questions.
Well, if we don't overrule Hatcher and change the rule, can you respond to opposing counsel's claim as to what we should do with the cases that he described as in the pipeline? Do we need to do anything?
I don't believe so, Your Honor. Certainly not with this case before us, but even the ones in the pipeline. There is a right to appeal, and as you heard from Mr. Harmon, the summons says they have a right to appeal and a right to a jury trial. So there's no due process concerns there with the ones that are in the pipeline. And we need the Hatcher rule to protect litigants, to protect parents, and especially to protect the children. Thank you, Your Honor.
Good morning, Your Honors. Bill Ladd from the Michigan Children's Law Section on behalf of the children. And I would note, first of all, I would agree with Mr. Sankaran, adjudication does matter. and having that right to appeal from that adjudication and that original disposition from that adjudication is consistent with the court rule. So at that initial point, the parents and actually the parties have the right to appeal from that decision of the court. And it's at that point that the issues of the status of the children outside of the home becomes most important and most immediate. So there's that opportunity to challenge that decision. In that case, that's the essence or the basis of this court's decision in Sanders, that the adjudication was important in these proceedings. Then, in child protective proceedings, these cases are continuous in nature after that, which means that at every dispositional review hearing, the parents have the opportunity to challenge the basis of the court's jurisdiction. And then, at the end of the case, the court considers all of the proceedings as the basis for its termination decision. In that sense, the case is continuous in nature. But it's continuous in nature because the appellant throughout the case has the opportunity to challenge the adjudicatory decision. This court in Remand took note of the fact that the parents, after the case was reversed, would have an opportunity pursuant to the statute dealing with review hearings and the statute providing for a rehearing, that the parent could challenge the adjudication. So given...
Mr. Ladd, I understand your view to be that you think that where parents were not told of their right to appeal, the Hatcher rule should not apply. So in this case, it should not apply. Is that correct?
In circumstances like that, I think the remedy, this court has to look at that situation as a glaring example of why this court has to amend the court rule. However, I think that essentially, as Chief Justice Markman says, this court also has to look at, in these cases, questions of harmless error. And in this particular case, the appellant is not challenging the basis, the factual basis for the adjudication. The court clearly had a factual basis to take jurisdiction over the parents and the children. And the appellants here before this court are not challenging the factual basis for termination, which is a compelling reason for this court to find that any error here, even procedural ones, is harmless at best. And it's particularly true because, unlike cases like criminal cases where harmless error is also very important, in this case you have the added fact that the children are an essential party in these cases. The court has to look at, in appellate analysis, the interests of the children in harmless error analysis.
Let me try again. I think, is this right? Hatcher doesn't bar a parent in a case like this where they're not informed of their rights to appeal from challenging that underlying problem. They can challenge that post-termination. You just think they should lose in a case like this where there was a sufficient basis for the adjudication? Is that about right?
I think that
on the merits.
Well, both on the merits and the question of the effect of their ability to challenge that original adjudication, I think that they've had ample opportunity to do so and they failed to raise that properly. And so the thing that this court has to look at is that the question of collateral attacks should be consistent with how this court applies that in criminal cases, because the most comparable situation is a probation violation case where a person cannot appeal if the facts or the basis or procedure of the original trial in a violation of probation. So I think that the Hatch rule is particularly compelling in that situation. I would conclude by noting that if this case were to be remanded, as Justice Markman noted, the proceedings would extend for periods of a number of years. That's been my experience in cases where they've been remanded from this court and from the Court of Appeals. It's not a simple matter, and nor should it be. And the adverse effect is primarily on the children. These children are in a stable situation. They're ready to be adopted. And it's this case that stands in the way of these particular children. This court should always consider the specific children in these cases when making its decision. Thank you, Your Honors.
Thank you, Mr. Ladd. This case will be submitted.